attorney of AZ Legacy Law Group. Hopefully everyone can hear. I can kind of hear bounce back. So hope that doesn't affect. Okay, maybe a little down here a little bit. Okay. All right. So yeah, back to myself. I've been a practicing attorney since 2014, and before choosing the practice primarily in estate planning, I've actually practiced in several different areas of law, like criminal, family, disability, consumer law. But I found that none of those really is a fit for my personality. And then when I got an opportunity to be able to learn about estate planning, I fell in love with it. And every day coming into the office was just it's not a day of going to work. It's a day where you come in and you get to help people, you solve their problem. And surprisingly, there's just so many problems. When people have their estate, or if they pass away, they have these probate, they have these questions. They don't know what they need to do. And that's when they come to an attorney. And it makes me happy to be able to provide that service every day. And instead of just coming to the office and litigating and, just basically, the typical attorney, right? When we practice law, it's mainly about litigation and it's costly. And there's really no side that comes out winning at the end of the day. It's just both parties losing. But for something about estate planning, when you get to help people, it's actually win-win for both sides. And even if a family comes to me when have a probate litigation or a trust litigation, you would think that would be a losing-losing situation. But sometimes I'm able to get the family to come together and come to a perfect solution. And that's where it makes me the happiest, to be able to produce a win-win result for everybody. And so the reason I'm here today is obviously not to go over all of that, but to give you guys a basic view of, why you should have your estate plan together, and then why you want to avoid probate and all those costly legal fees that potentially could happen, but could be avoided if you had gone through and do your estate plan. And so I see on the table that my legal assistant should already pass out all the packet here. And what I'm going to do is I'm just going to go one by one, because this is the presentation that I prepared for today. And feel free to ask questions during the seminars, and I'll try to answer them, because I know some people here already know a lot about this, and then some people don't know anything about it. And maybe you have a personal situation that you want to know the answer to, and today is an opportunity for me to answer those questions too. So obviously I just went over it, but the first page is about my firm. We created it roughly about 3 years ago, but our primary area of practice is estate planning, and our secondary area of practice is business law. And the reason why we added that is because so many of our estate planning clients have a lot of businesses, and they will ask us to support them, to give them, help. And so eventually we did so much of that, we incorporated it into our practice. And in estate planning, you would think that generally it's just about creating a will and a trust, but it's actually more than that. So obviously there is the creation of the wills, the trust, the power of attorney, but then there's also the after death side, where you go into the probate and then the administration of the estate, as well as possibly probate litigation or trust litigation. And then the other one is guardianship and conservatorship. Now, I don't know if anybody here knows anything about that, but basically guardianship can be for a minor or an adult. Say you have, your mother. She has dementia. She can't remember. She can't manage her own asset. Well, you can't just go in and do everything for her. You can't just go to the bank. You can't just apply for Social Security. In order to do that, she needs to have a guardian. And that's where we would apply for a petition to appoint one of the kids to be the guardian. And then for conservatorship is where, let's say, father or mother passed away early, and there's this minor child. Well, there's a substantial amount of money that's going to go to this child, but this child's not old enough to receive that money yet. And so the court wants to make sure this money is protected until the child is an adult. And that's where conservatorship comes in. And again, we will petition the court to assign somebody to oversee this money. And of course, the court oversees this money too until this child is an adult. All right, so on the second page, estate planning. Do you need one? And a lot of people come to my office, they think, you know, I have to have a lot of money in order to get an estate plan. But that is not true at all. I say almost anybody who's an adult should have one. Now, sometimes we even encourage kids who just turn 18 to get an estate plan together. Simple as just having a will and a power of attorney in place, because that would avoid the whole guardianship and conservatorship issue that might come up as well. And of course, you know, as soon as you have kids, you got to make sure you want to have an estate plan together, because who's going to take care of your child? You want to have someone that's trusted instead of having the court appoint someone for you, right? And of course, an estate plan makes your wishes clear and helps avoid family dispute. Because if you just leave it to the ether, nobody knows what you want, right? And then the people who are interested in this amount of money that you're leaving behind is going to start fighting over it. Whereas if you leave a clear instruction, nobody's going to fight over it. Everybody knows what they're supposed to get. And of course, a proper estate plan can preserve asset and provide for loved ones. So that little paragraph down there where it said, don't wait until you know or suspect that a lawsuit is on the horizon. It is too late to put a plan in place to protect your asset. Now, this goes more into asset protection, which I'll talk about later. But here's the thing. When you know a lawsuit is about to happen or a lawsuit is filed, it's too late to start protecting your asset, right? Because then it's going to look suspicious to the court. You know, why are you getting rid of all your house, all your bank account, right at the moment when you're about to be in trouble? What are you hiding from if you're not doing anything wrong, right? So when you have a substantial amount of asset, you need to put a plan together to protect your asset before you get to that point, especially if you own a business. Thank you. And of course, the other thing is like you want to reduce your estate taxes. Okay, so this next one, if you take a look at this one, it's called especially needed if. So if you check up any of these, then you should have an estate plan together. So the first one I put, because that's the highest priority for me, is if you have minor children, definitely need to have that in place. And if you own property, yes. If you own a business, yes. Or someone in your family, oh yes.
Just a quick question.
Sure.
Minor children, does that include grandchildren?
Yes, actually. So if your will or your trust leaves some of your asset to your grandchildren and they're minor, you do need that in place. Because otherwise, if something happened to you, it cannot go to the minor. It goes to the conservatorship, and that will trigger two things: probate and guardianship and conservatorship. Guardianship is a maybe, so that's why I said two things. Okay. And then the other one is someone in your family is disabled. I don't know if anybody here has anybody that has a family member that's disabled, but they rely a lot on government benefits to provide for a lot of their medical needs, right? And so if you accidentally, because out of your good will, you want to leave some asset to this person, you're actually depriving that person of the essential benefits that they need by doing that. But there are proper ways to do that that would not deprive that. And by doing your estate plan, you can leave a substantial amount of asset to take care of this person without depriving any of their benefits. Mm-hmm. And another thing is your spouse is not comfortable with financial matters. And I see this, I don't know about the general, but I see this more in Asian family where the wife doesn't really do much of the taking care of the finance. It's mainly the husband. And so if something happens to the husband, the wife really doesn't know what to do. We actually have that case right now where wife comes to us after her husband passed away. She has never dealt with bank account, doing financial. And so now we have to help her and guide her do that. And that's, a lot of work to do at that point. Mm-hmm. So like if you have someone you trust that you can appoint to assist this spouse, it makes everything a lot smoother. They can access the bank account. They can go through whatever that the husband left behind, makes it easier for the family. And then long-term care is concerned for you. Long-term care is probably one of the questions I get the most whenever someone comes to me. At some point, people they're not that lucky where they get the family to take care of them, or they have a substantial amount of money to take care of their health when they're old. So usually what it is they have to go to a nursing home, or they have to have a nurse come take care of them at some point. And so this is where, if you cannot afford it, the state will provide that for you. However, when the state provide that for you, they're going to want that money back when you pass away, right? Yes. It doesn't always happen, but the state will actually pick and choose. And for me, it's very random on who they pick. But I've seen states send a letter out to the state and say, this is how much long-term care has cost. And typically you can average it about $5,000 to $7,000 per month. So depending on how long that person has lived and used that, it could add up quite a bit. And so they want the state to pay that back. Mm-hmm. And if you don't have the long-term care insurance or something like that in place, then make your estate plans that way you can protect it, leave your asset to your children without depriving yourself of that. Okay?
If you don't have that, you shouldn't have to be the one who or your husband. You don't have insurance.
Right. So if you don't have insurance, then whatever you own by the time that you die, that the state can go after it. So like
after the relative that alive, the living one, right?
I think I'm confused by your question. Say it again.
I think it's just like how the living ones are responsible for funeral costs and also responsible for all that care that was done, right?
Oh yes.
All those
Okay,
costs.
that's what my
Yeah, so it's gonna be both sides.
Yeah. So one of the things that happened during probate is we have to send out these notices to everybody, including doing publication in the newspaper, so that creditors can come out and make their claim.
The debts, they still are responsible for debt.
Correct. And so the person represented has to pay all those debt, including the debt from the state. And usually a lot of that is medical bills, right?
Is that specific to Arizona?
No, it's actually in all 50 states. Yes. Mm-hmm. Now, as far as long-term care rule-wise, state differs a little bit, but the general rule is that if you have to use long-term care, you tend to have to pay it back. Mm-hmm. Sure.
So when they come to the person that they have to pay back to the state, is that going to be like after they pay all the debt first and then pay long-term care, or like same time?
It is the same time. There is an order of priority on what kind of debt you have to pay. So what it is funeral costs first and attorney fees for the probate. And then after that, it goes down to like those who have like a lien in your house. And after that is medical debt.
Which is basically like if you still have a mortgage.
Right. Yeah. So the mortgage always get out payout first. That's why they're the first lien holder on your house. Mm-hmm. But let's say if your house is paid off, then as next in line is going to be the medical debt. Mm-hmm. And another thing is you are not legally married to your significant others. Now, this one is not so significant to some other state, but it is very significant to Arizona because we do not recognize common law marriage here. Mm-hmm. Yes. Oh. Yes.
They do in Texas. They do it in a lot of states.
Yeah, in a lot of states they do. So when I was from California, so when I got here and I learned about this, I'm like, what is this? Why wouldn't they recognize this? And we had a case that called in. It was kind of a sad case, but this couple has been together for more than 15 years. They treat each other as husband. They actually got like a ceremony when they're out the country. But the problem is that they never got that piece of paper that say they're married. And so when this husband has issue with his brain, his brother put him into one of the psychiatric facility, and the brother actually hated the wife, so would not let her visit. Yeah, and because she didn't have that piece of paper, she has no authority to visit him.
She's not paying.
Correct. So you see the problem there? Yeah. All right. So the next one, what is probate? So the probate is the judicial process whereby a will is proved in a court of law. Essentially what it is that it's just a legal process where the court determine whether this will that was left behind is a valid will or not. Right? Because sometimes people make will and then they change their mind and they create a new will. But if somebody who had the old will found that their name was in it, they should get everything. They try to produce that will to the court. Well, is the court just going to automatically follow that will? No. They're going to make sure that you produce the most recent will. Right? Now, what happens if someone dies without a will? Then it's called intestate. So intestate is where, by default, the state determines who has the first priority to get your estate. And that's usually your surviving spouse, and then your children. And if you have no children, then it goes up to your parents, and your parents down to your siblings. Now, a lot of the situation I see nowadays that makes probate complicated is where you have mixed family. Husband and wife both had children from prior marriage, right? And in that instance, then the surviving spouse and the stepchildren actually gets to divide the estate in half. And then probate can cost around 5% of your estate. And this is why you want to avoid probate. It's not just the attorney fees that is involved. When you do probate, you have to do an inventory, appraisal, and all of this has been done with the court if it is required. Say if there's somebody in the family who is a stickler who wants to know everything. Well, you have to go and do an inventory. You have to go hire someone to do an appraisal. If you own a house, you have to get that appraisal too. All of that becomes cost, right? And then in addition to that, the attorney fees on top of that. And if you have to sell the house, that's also a realtor fee that has to be included too. So that's why I'm saying it's 5% of the estate. And then the other problem is that during a probate, assets are generally frozen. Now, this creates a lot of difficulty for families sometimes, that they come to me after waiting for so long. They have no access to money to pay for the mortgage or to pay anything else. And now the house is in foreclosure. And this is where we really have to work really fast to get the court approval. And sometimes the court can be tricky because it's up to the judge. If the judge decided that day that he's going to give us the power to go ahead and get the money out of the bank account, or he's saying, you know what, I don't trust you guys. I'm going to make you guys go get a bond. I'm going to need you guys to do a restricted account, all this extra stuff before you even get any of that. And that could drag on for months.
And adding more costs.
Adding more costs. Yep. Now, Monica here has dealt with a couple of those, so she knows very well. Stress her out quite often. And of course, typically on average, it takes about 6 months to a year to complete an uncontested probate. And that's the smoothest probate you can have. Mm-hmm.
How about a contested one?
Oh, it could take years. Yeah. And then, of course, in a contested one, you're going to have two opposing attorneys. The attorney for the person representative, and then the attorney for one of the interested party. And that's where the litigation comes in, and it's going to drag on for years. Mm-hmm.
I have one probate case right now that is over 4 years old, but it's not at let me just preface, it's not our firm. We took it over from another firm because the families were not getting along. So there was a lot of information being relayed, and then the PR, the personal representative that was assigned to the probate, handle the probate, was just surrendering and fighting with these people. They wouldn't call, they wouldn't communicate with each other. And I finally put the hammer down and said, help me help you, and you need to do this. Otherwise, you're not getting your money, basically.
Yeah.
Do you want your $200,000 that you're each getting or not?
Mm-hmm.
So, And sometimes they just have to swallow their pride and say, well, she did, everybody's so nitpicky. She got this, he got that, And it's just like, just be quiet. This is what I'm getting. So it's really a lot of, and these people are adults, they're not young people. They're
Yeah.
old.
Are you saying that eventually if they'll just compromise?
Yes, absolutely. We have them sign the waiver, in order, like, he's talking about the inventory. That is extremely, we don't do that because I don't have time for that.
Yeah.
We have to hire someone to do that because it is way too costly and time. And so we suggest to our clients, the beneficiary, if you sign this waiver and inventory, this will help expedite the probate. Therefore, you can get your distribution quickly. So,
Yeah.
we really encourage that.
And I would say we're actually pretty good at, mending family together and getting them to come to a resolution instead of trying to drag the case out. And I believe were you raising your hand for a question or?
Oh, actually, my question would be that last sentence, having a will does not avoid probate, like, oops.
Oh,
That last sentence that you had,
having a will does not avoid probate?
Yeah.
Oh, yes, that's a very important one. I almost skipped over that one. Thank you for pointing that out. And that's why I ignore it. But there's this myth sometimes that if you have a will, it's good enough. Because, I left my instruction. It's easy for the next person to carry it out, right? Well, that's not true. Or for the court, they don't care if you have a will. They want to make sure it is a valid will and for it to be carried out. Like I said, people can just create a will and then destroy it and then someone else create a will. So that's where the probate process come in. Right? But there are ways to avoid probate. And I'm sure some of you already heard of it. But let's say you have a bank account, right? And you designate a beneficiary with the bank. The bank knows who's supposed to get that account. So it avoids probate. It goes directly to the beneficiary. Your retirement account, you can do that. For your house, you do need to do this thing called a beneficiary deed for your house. And that's probably the cheapest way to do it, but it's not always the best way. And the reason I say that is you should only do a beneficiary deed and a will if your instructions are very simple. Say you have a couple kids, you want them to have it. If you find that potentially your kids might have problem working together, or you want to give additional instruction, the beneficiary deed is not a good tool to do that. And the other thing, you got to make sure your kids are adults. If one of them is a minor, they cannot receive that asset. And so your beneficiary deed doesn't do any good.
And I'll just preface that, sometimes when you make, as an adult child, you make poor choices, you get into drugs or alcohol or what have you. If you pass, would you really want that adult child to get all this money from your home or whatever? No, you wouldn't. So therefore, we always highly suggest a trust, because the trust will protect that individual, make them get help. Otherwise, they don't get that distribution.
Yeah.
I have a question.
Sure.
This is from our association asking. Her husband just passed away recently, not this and before he passed away, he said to her, like, the house will belong to you, but he just happened to set up on it. But when he passed away, she's entitled and she's a wife, but she doesn't have a name on the house. And kids show up, the kids said that they have a will, and then she knows that the will is kind of fake, or maybe not fake, or maybe it's a real will. But is there anything that she can do to basically fight to get the properties? And it's not come back to what we were just saying, like having a will that's not probate. Like if she hired you to represent her, which is something win the house or win the asset that she belongs.
Yeah, of course. And in that situation, she should definitely seek out an attorney to review that will first. So one of the things that the court actually requires is original will. It has to have a wet signature. a copy is not sufficient for the court. Yeah. And so that's where like we ask the person to bring in the will, and we look at several things. Obviously, the first thing we look at is the signature, right? And then we will look at that past signature to compare. Does it looks like their signature today? Other thing we look for is the witness, because the will requires 2 witnesses. And then the other one is most of the time there's also a notary on that. And so we would Google up, we would search the identity of these individuals to see if they're valid or not. Generally, if a will come from an attorney office, it is valid, right? So the notary or the attorney name is usually stamped somewhere on that piece of document, and we wouldn't be contesting that in that case, right? It's the same thing when we create a document. Our name is on it, so we have to defend the integrity of that document. So if somebody say you have a fake will, well, I'm ready to testify that my office was there, my assistant was there, my notary was there, and we listen to the client and we draft this will. And the thing is, like, when we create a will or a document for anybody, they have to have mental capacity. So you can't just bring your mother into my office and she can't answer anything and then I draft a will and she sign it. It doesn't work like that. I have to make sure she knows what she's doing. She knows who she's leaving her stuff behind. Otherwise, I'm going to have to send her home.
Question from online. This person, she has a nephew that's not the U.S. citizen or not, maybe holding a green card or not legal here, and she set her up as the beneficiary.
Yes, anybody can be a beneficiary. You don't have to be a U.S. citizen to be a beneficiary. However, if assets get transferred outside the United States, say this beneficiary is from another country, then there is possibly a foreign tax that might happen in that case. Now, I can't answer a tax question, so that's something a CPA would answer. But if it's a U.S. citizen, permanent resident in the U.S., and the asset stays here, then generally it's going to be exempt from any inheritance tax.
Another question, like a small business, if I own a small business, is that the easiest way to avoid probate? Set up a beneficiary as like bank account?
So the problem with businesses is that there's no such thing as a beneficiary deed or a beneficiary for the business. How you would actually do that is when you set up the business, there is a member and there's a manager, right? Now, and you should have an operating agreement. And this is what I see typically a lot, is that a lot of people set up these LLC. And it's very easy to set it up because you go into the computer system, you type in information, boom, you have an LLC. But when it comes to when it matters, when it comes to litigation or when it comes to passing down to the kids, where is the document to prove that this is supposed to go to the kids? And if you don't have the operating agreement to say who's next in line, who's the next manager, then unfortunately you're not going to be able to pass that easily. Now you have to go through the probate system to prove to the court who gets that company. Yeah.
Yeah, I have a same question.
Sure.
Like, for example, like if he used to have me as a beneficiary, and if I know that he has, but the company maybe in debt, this is going back to me as ex-wife, but my name was in beneficiary.
No, if you're saying you're the ex-wife at this moment, then you wouldn't be liable for the debt of that company.
Or even my name is as a beneficiary because he put company name in the trust, and the trust show that I'm a beneficiary.
Right. But even before you receive that company, all debt has to be paid first.
Okay.
So you wouldn't be liable for any debt that would be above that.
Okay.
Right? Yeah. Now, if you were the wife, then any debt of your husband, you're also liable for that.
Right.
Right. I didn't miss any more ballpoint, right? Let's go to the next one. And this is probably what you guys want to know the most. When you come to an attorney office, you're going to be asking them, what's the difference between a will and a trust? Why can't I just go with a will? So the first one is, if you see here on this left-hand side, this is for the will right here. And this is always for the package, for the trust. So, like I said earlier, if you just have a will, typically it goes to probate, and probate becomes public record. You guys heard the celebrity story, right? Where they go through probate, that's because they didn't have a will. And so the whole entire personal asset, family, everything becomes public record, because that's what probate is. They have to let the creditor know. So anything you own becomes public record. Whereas if you have a trust, it's all private. Everything get transferred through the trustee. Nobody needs to know about it.
The trust and your will are not recorded.
Right. The other one is effective only upon death. So the will is only effective upon death. Whereas the trust, you can use it while you are alive, when you are incapacitated, and as well as beyond the grave. The trust lasts up to 500 years. So you can leave any instruction you want and make your trust live up to 500 years and carry it out. Yeah, the trust never dies. And then the other thing is obviously probate takes a long time. It's 6 months to a year. Whereas trust, it just transfer asset within days. As soon as the trustee comes to me, take over the power, all they have to do is start doing the document to transfer the asset to the beneficiary. Or if need to, then they just continue to administer the trust for the benefits of the minor. And then the will is less expensive to draft, but costly to administer. And the reason it's costly to administer is obviously the attorney fee involved for the probate, the fees for the administration of the estate, and all the other fees like the appraisal fees and realtor fees and all that. And then the problem with the will is that it does not manage assets for minors. Hi. Did you want to come in? Okay. All right. So this is pretty important. The will does not manage asset for minor. So if you accidentally say in your will, I'm going to leave so-and-so to my kids, and should my kids pass away, it goes to my grandkids. The problem is if it ever goes to your grandkids, that triggers probate, guardianship, and conservatorship. And those three cases are very costly to do. And then the other one is that assets are frozen upon death. I discussed that earlier, but you want the family to be able to have access to the money right away when they need it, especially if they're not like the primary earner in the family. And then the other one is that the will is easy to contest. Now, typically when somebody try to create their own will, and this happen a lot, and because there's like Legal Shield and all these online stuff, you just download something, put your name in it. It's easy to contest for us personally as attorneys. When I look at the will, if it's done by an attorney office, I tend not to go after that because I don't want to go against that attorney office. It's going to cost me a lot of time and money, and my clients a lot of time and money. Whereas if I know somebody created their own will, I know I have a better chance of winning that case. Right. And then incapacity management. This matters a lot for the trust creator. Because at some point you're gonna get old, you might not remember what you do, or you slow down, you cannot manage your asset anymore. This is where the trust kicks in and takes care of you. It requires that the trustee take over control of all your asset and use those assets to take care of you first. Say you're passed out in the hospital, you're in a coma or something like that. During this time, the trustee can take care of everything that needs to be taken care of. Okay. And then of course, the trust is more expensive to draft, but faster and less costly to administer. And then obviously it's very difficult to contest the trust. Because in order to change the trust, you actually have to go in and do an amendment. It's not as simple as crossing something out and writing something else into it. All right. And then the next page is about the benefits of a living trust. Okay. The main benefits are it saves your family time and money by avoiding probate. And then having a trust is extremely useful if you become incapable because of physical or mental illness, which I just discussed earlier. And then it protects your beneficiary from creditors and lawsuit. Now, how it does this is that a trust has this provision in it that should your beneficiary, meaning your children, ever get into some kind of bad drug habit and they have creditors, the creditor knows that this kid is from a rich family maybe, and is going to sue this kid because they know this kid's going to get inheritance. Well, the trust will put up a wall and not disperse any money and basically force the creditor to come into a settlement before it passing out money to the kids. And that's one of the ways to protect your asset from being dissipated. And then control how your assets are being distributed from beyond the grave. You can put condition on how and when your assets are distributed after you die. And this is, I would say this is pretty important if you guys want to build a foundation today for the future generation. Have you heard the term trust fund, kids? Now it might sound bad, but but if you do it right, it can be a very effective tool, because the trust, you can leave many conditions. Say, one of the conditions that I heard other attorney use is like, my kids can only get so much money that equals their income. So that encourages them to actually work harder, right? To earn more income because they're going to get more of the money. So if you do it right, your trust money actually build upon itself. And it creates basically unlimited income for future generation. And if you select the right trustee, they continue that legacy. And that's where, generational wealth come in. Another thing is reduce estate and gift taxes. Now, this matter more for a family with like really large estate. Usually, typically, a person is exempt up to $12 million. So a couple is up to $22 million. If you have anything beyond that, that's when you start having to consider reducing estate tax, because estate tax can be 30 to 40%. And then the other one is special needs planning. Having a trust can prevent your children from not qualifying for government benefits. So this one, I kind of went over a little bit, but if you have someone who is disabled in your family, you don't want to just pass on inheritance or asset to them. You want to make sure it's in a trust. And usually how we set that up is those particular assets go into a special needs trust to provide and take care of that disabled individual, but not to give money to that individual. All right, so where do your assets go? If you guys want to know what can go into a trust, almost anything can go into a trust. There are very few items. I would say 99% of assets can be put into trust. And those items that cannot be put into trust, usually you can probably liquidate them, put them into a bank account, or designate a beneficiary for them.
Well, an important thing about that you're probably well aware of is if you put your home and your cars and all your stuff in a trust, and then you have a person appointed, whether it's you or whatever, to manage the trust. If you're in a car accident or some kind of other thing, they have to sue the trust. They can't sue you individually and take your money or take anything else that you have. Is that correct?
So kind of. It depends on what kind of trust you have. Most people have this thing called revocable living trust.
Irrevocable.
Yeah. So irrevocable is another type of trust. If you have the revocable, which is the one that you can amend, terminate, and change whenever you want, and ask the creator, because you have absolute power over this trust, it really doesn't give you that protection. Because a creditor can just sue you and say, hey, take your asset out of that trust that you are trying to protect your asset from. And because you have that full power, you can just reach in, grab the asset, and take it back out. And so that's where the attorney will be able to get your asset. But if you have an irrevocable trust, you as a creator actually don't have the power to come in and take the asset out. And that's why even if I sue you and I win the lawsuit, I actually have to sue the trust. Right? And it's very difficult to sue from a trust because you have no power over it. The person that is at fault is you. And so that irrevocable trust is where the asset protection comes in. And because you mentioned that, that's where long-term care comes in, right? And now there is advantage and disadvantage to the irrevocable trust that you have to consider before you put your asset into it. And obviously the first one is that you will lose control over your own asset. You have to, you get the ability to write down all the conditions you want. But from the moment you create that trust and you transfer asset into it, you have no power over it anymore. So that's something to consider.
So the revocable trust, once you set it up, if you buy another property or buy another vehicle or buy something of extensive value, you can add that into the trust. Is that correct?
You can add an asset to the trust anytime. It's a matter of being able to take the stuff out. Revocable trust allow you to do that as easily as you want. Irrevocable trust is a different matter. You have to actually go to the trustee and ask the trustee. And if the trustee say no to you, then unfortunately you won't be able to do anything about it. However, the trustee has a fiduciary duty. Their whole duty is to follow the instruction of the trust. As long as they don't violate the duty in the trust, you really can't sue them.
And then the irrevocable trust.
You cannot. Yeah, because we actually had a client who created this irrevocable life insurance trust. And then later he got remarried. He wanted to come back and amend this trust. I read through the whole entire trust. It did not give him that power. So unfortunately, you cannot amend that trust. Right?
So you should probably put your life insurance policies in the trust. Can you do that?
Depends. The reason why people create this irrevocable life insurance trust is because their asset have already exceeded the federal tax exemption limit. And one of the ways to bypass any additional tax is to buy extra life insurance and put into this trust that will eventually go to their children. And then, there won't be any tax to the estate because this life insurance is like a couple $1 million, right? So it's just mainly about strategies and why they use it. Mm-hmm. Over here, I put that for retirement account. I do not recommend putting into the trust directly. The IRA, traditional Roth, 401k, a 403b, and 457 plan. Those retirement account, what I recommend is put your spouse as a primary beneficiary and then put the trust as secondary. The reason being is because the spouse gets to keep those retirement account longer, allowed to earn more. Whereas if you designate any other person or any trust as a beneficiary, there's this 10-year requirement that you have to take out within 10 years. All right, so let's go to the next one, asset protection.
Let me ask you about the beneficiary. If there are two beneficiaries, 50%, but one already passed away, will it 100% go to the other beneficiary or go to the heir of the first, the other one who died?
It depends on what you put. If you put it goes down to the kids, then it will go down to the kids. But if you don't, then it will usually go to the survivor.
The other beneficiary, 100%.
Yeah. Now, are you talking about the beneficiary in your trust or in your account, your bank account?
In the bank account, but those two beneficiaries are not related. Like one is a brother and the other one is spouse. So if the brother dies before the disease, will the 50% of the fund that would go to the brother will go to the spouse instead?
No. From what I know is bank account, they generally let you list down the name of who gets it, but unless you put a contingent beneficiary, it actually go into probate to determine who gets next.
What good percentage of the ownership? They'll make it for 50%. So when it comes to deceased client show up, then the beneficiary, the beneficiary that earns 50% will get, but the rest of it, they might have to go on probate.
Yeah.
Because we have to wait for the will or person in trust. So, but if you have a bank account and the other is 50%, the other 50 might have.
Yeah.
And that's the same for investment account?
It's the same, yes.
So, but if one of them passes, you can go up update, but you might have accounts in a whole bunch of places that you forget to update, and that's why you might get in trouble. But if you don't update to 100%, that can save you.
Yes, so this actually happened quite often, where clients have a trust, they put majority of the asset in trust, but they decide to put a couple account outside of trust, and that's where they list the beneficiary. But unfortunately, one of the beneficiary passed away early, and that triggers the probate, particularly for that account.
Another question from online. This person said, I have my husband's name in my checking account, two-person name in my checking account. Is that good enough for him to receive the fund after I pass, or he have to go in and say the husband has to?
So I would say that's good enough, because as joint account, whoever is the last title holder gets to keep the whole bank account. So, however, what happened if both of them are gone? Then again, that triggers probate. You're welcome. All right, so asset protection. Think of asset protection as multiple layers of multiple walls surrounding a castle. And how you do that is, I noticed, I wrote down here, there's 4 layers. Layers 1 is having a revocable or irrevocable trust. And then layer number 2 is own an asset that are automatically protected from creditors. And what are those assets? IRA, Roth, IRA, 401k, 403b, those have automatic protection. Creditors cannot get into them. And then homestead protection is for your primary resident. In Arizona, you get protection up to $400,000 for your primary resident. So if someone sue you and they win a lawsuit, they actually can't force you out of your home, because nobody wants to leave you homeless. And then even if you do sell your home, you get to keep up to $400,000. Life insurance policies is also another one. Creditors cannot force the owner to surrender the policy or borrow against the policy. And then layer number 3 is business structure, LLC or corporation. Say you own multiple rental properties. You don't want to put everything in your name, because if you're being sued for something, it all get claimed into that one lawsuit. So you would technically lose everything. So what you want to do is set up separate businesses called limited liability. And the name is exactly as intended, limited liability, right? And of course, how to protect your business is you need to have a solid operating agreement and bylaws in place. Proper record keeping, trademark, patent, copyright, etc. So when you have a business, you have to treat it like a business. If you treat it like a toy, then the court can disregard that business entity and consider that your personal asset. And that's where you will lose your asset. And then the last layer would be insurance and umbrella insurance. So even if you don't have a business in place, you should have the proper insurance in place, and then of course have an umbrella insurance to cover everything that could possibly happen. Because a lawsuit, when it happens, it can be very costly. All right, so the next one is about estate tax. If you are single and your asset is below $12 million, you don't have to worry about it, because that's the exemption limit. However, I've been hearing the rumor that our federal government is planning to reverse this, and possibly in a couple of years, they might change the law and reduce the estate tax down to about $7 million. And so if your asset is around there, you might want to start planning now. Oh yeah, I did put that here on January 2026. The exemption amount reversed back to this 2017 level, 5.49 million and 11.8 million for married couple. Now, I'm not sure if they're going to do it. I hope not. And then for inheritance tax, if you have to pay inheritance tax, it's about 40%.
Wow, so if you inherit $200,000, you lose almost half of it.
Pretty much, if you're over the exemption level. Yeah.
So whether you have a living trust or not.
Yeah. Pretty much. But if you have a trust, the trust will design ways to dissipate some of that, so that way the beneficiary doesn't take it all at once. Say like for example, this thing that I mentioned, gift, right? $16,000 per year. During your lifetime, if you have so much asset, you can start gifting to their trust, create the trust for the child. And from your trust, every year, you move over $16,000 to that trust. As a husband and wife, you get to double that. So that trust, the kids doesn't get access to it because you create it, you get to set the condition. And so by the time they grow up, they get to use that money. If you have company, etc., you can set up company, put your kids into it, etc., like that. And then, of course, the trust, there are different type of trusts that will allow one spouse to claim the full maximum exemption, leaving the other spouse more room in order to claim more exemption down the road. All right, and here's another thing. People only think about federal taxes, but what about state taxes? So take a look at some of these states. Connecticut, a state tax of 11.6% on a state that is above 9.1 million. That seems high, but let's go to some of the lower state. Illinois is only $4 million. And Oregon, if you own over $1 million, a state tax of 10%. Right? Rhode Island, 1.7 million. One of the good things about Arizona is not listed on here, so you guys are good. But you own asset in any of these states, you do need to be concerned about it. Let's see. California's not on here, so you are good. Sure.
So when it comes to estate tax, federal plus state, right?
Correct. I know.
And you said 40% that this if you have a lot of money like 5 million, 11 million like this, but if lower than that, what is the rate? If you like have 3 million, what is the rate for the
So there will be no tax if you're at $3 million. Remember, your asset has to be at that exemption first. So say when you pass away, you have $14 million, right? That $14 million is supposed to go to your kids. Your kids can claim the exemption up to the $12 million, but that last $2 million, that's what the federal government is going to hit you with that 40%. Yeah.
There's somebody that just get like $250,000 and they don't.
Correct.
So will the state as well, won't it?
I'm sorry?
Will the state hit them up as well?
Yes.
If you're in one of these states here.
Absolutely. So add that percentage on top of the federal.
So Arizona zero.
Arizona zero. Yeah.
So is that a lump sum that is distributed around? It won't be taxed? This is one lump sum.
If you take it all at once, you have to file that tax right away. But the trust allow you to take it slowly if you want to. Because usually the only time you take something out is when you start reporting tax and then start paying for it. But of course, I'm not a tax expert, but when you do have a large estate like that, what I do is I bring in two different individuals. I bring in a CPA and a financial advisor. And those two will collaborate with me to create a plan that will minimize your estate tax. It's based on the asset that you have in the state. So even though you live here, but you might you might go to Illinois and you purchase a couple rental properties over there, or Oregon. Any property over there will have to be taxed by their state law.
Any state that don't have the estate tax. The state, yeah.
I'm sorry, like any state that's not listed here?
Yeah, like is there any state that have like 0%?
I don't remember that on top of my head, but the fact that I only list those states because I know they have estate taxes. Majority of other states have either very high or none at all. But of course,
you can Google that.
Yeah, if you have asset in those states, I definitely Google them. All right, so how to avoid probate? Let's say you don't have a trust, or you don't want to spend the money of having to create a trust, there are ways to avoid probate. And one of those ways is designate a beneficiary on all of your financial accounts. Designate beneficiary on all your retirement accounts. And in Arizona, you can also designate a beneficiary on death of your motor vehicles. So if you own expensive vehicles, you should do it. So the probate limit in Arizona is $75,000 or more for personal property. So if you own a car that is more than $75,000, I would recommend doing that. If your bank account is over $75,000, then you need to do that too. And the other thing you do have to consider is that if you have multiple accounts and they added together is over 75, that also trigger probate. Now, if it's below the 75 altogether, then what we do is we just do a simple small affidavit. You can take that to the bank and they will actually write out the checks to the beneficiary.
This is not one single account, it has to be offline, right?
Yeah, because when you do the small estate affidavit to collect the asset, you have to list out all the assets and basically let people know what it is that you are collecting. And that's why you add it all up together. Mm-hmm.
So how do you designate a beneficiary?
So in Arizona has this MVD beneficiary form that you can get online, or if you want, contact us. We'll give you one, and then you just put down the name of one of your kids that is going to get the car. You sign it, notarize it, and just keep it in your notebook. And if something happened to you, they take that form down to the MVD and they get title to the car. Mm-hmm. And then for real property, one of the way that you avoid probate is doing a joint ownership. So typically, husband and wife will own the house together in their name. And one of the important clause in those deeds is the right of survivorship. So that means if one party passes away, the other party inherits the house outright, right? Or the alternative is to do beneficiary deed. So that way your kids get the house without going through probate. Okay. And then this last page is basically, if you come to us and you do an estate plan, what will you get? We provide like either a will package or a trust package. And it depends on what you need. And usually that involves like, the consultation. If I know your estate is simple, I will recommend just a will package and a beneficiary deed, and that will accomplish the goal of avoiding probate. But if you tell me there's something more that you want, that you need a trust, then at that point I will recommend a trust. And then we go into a consultation on what kind of trust you need and what I need to put in that trust for you. Yes.
I have a trust. But do I need a LLC for rental property?
Yes. And I'm assuming you have a revocable trust, right? The one where you can amend and terminate it? Yes, okay. Then if you have rental properties, definitely put it in an LLC. Because if anything happened, say one of your tenant, you install a new stove, it blows up, and that family get injured or something like that, they can only sue that LLC because it's part of you doing the business. It's not something personal. And so say that damage is $5 million. Well, the house is only worth about $500,000, and that's the maximum you pay out for that lawsuit.
Which is an added layer of protection that we always suggest.
Right.
Do you do LLC?
Yes. We set up LLC, corporation, and that's part of our asset protection. And of course, our secondary practice is business law, and we provide the support for businesses. No.
So for the business law, do you do in 50 states or only Arizona?
Only in Arizona. Usually if it's involved another state, we would recommend that they go seek counsel in another state.
What if they have many business in any state?
Usually they would have to have counsel in different states for that. We can give them like basic guidance, but we always have to tell them that I'm not a licensed attorney in that state. There might be nuances, laws that I don't know about, and so it's recommended you go seek out an attorney over there just to get some advice. But as far as setting up the trust, setting up the business structure, so we set up Arizona LLC, but we also set up Wyoming LLC too. And then sometimes we set up different states, but that's more for the purpose of asset protection. Did anybody have any other question? Otherwise, go ahead.
So I saw on the list here, it says living will. Is there what's the difference between living will and
Oh, that's a good question. So a living will is actually a medical document where it's called an end of life care document. So when you're in a terminal condition, or let's say you're in a coma for a while now, and the doctor has now concluded that the chance of you recovering is not that high. So the difficult decision of having to pull the plugs now falls on somebody. And usually they would ask the family. But for family members, especially children, it's very difficult for them to make that decision. And so while you are alive, you should execute the living will where it specifically states what you want should that situation happen. And the doctor just have to follow that living will and execute it. Mm-hmm.
So that's totally different than like a will where you're designating what happens after, like where the assets come. Living will is just what to do if you basically become in a huge coma and can never.
Yeah, most people say they don't want to be put on a ventilator.
Right, my dad told me this.
Yeah.
Let's pull the plug type thing. How do you want to be treated? We have particular questions that we have on our living will. If your heart were to stop, do you want them to perform CPR? Why would you? I mean, I shouldn't say that. That's me. I shouldn't speak for it. But and then the other thing is like, do you want food and fluids prolonging your life? But I'm terminal. Why would you want that? Do you want to be taken to the hospital followed with? Do you want comfort care, or do you want your life to be prolonged to the greatest extent?
Yeah.
You have options.
Mm-hmm.
So it just makes it easier for the family, especially if that situation were to come about. And we see that a lot in our business staffing.
Mm-hmm.
And especially when you have a blended family, you're on your second marriage, and this side of the family are very religious, and they want to keep their child alive to the greatest extent, but you know that your spouse would not want that.
Mm-hmm.
And so then there's, it's really hard and a difficult situation. Well, some of us are old enough in this room to remember Terry Schreiber case. Remember that? She was on the bench forever, like years upon years, just sat, and she was not there.
Mm-hmm.
Yeah. If you had that, then she could have passed.
Yep.
Do you have a sheet like this for irrevocable and revocable trust, so you can compare the benefits or which one would fit your life situation better than the other?
No, because it's case by case for me. Because there's a lot of factors for me to consider when I put together an irrevocable trust.
So you basically do that when you're doing the comprehensive estate plan. Once the person or persons have told you that they want a trust, then you can say, well, if you go this way, you need to have a revocable, or this way, you need to have an irrevocable.
Right. Yeah. For example, the first thing I have to ask is like, are you willing to give a control of your asset? And the other thing is I have to consider the people you choose as a trustee, because at the end of the day, you rely on them, and you just pick in a random trustee. It might harm you more than any good it will do. Right? And so I got to know that person, because eventually that trustee has to come to my office and sign this document. And so I got to know that person know what they're going to be doing, and all the responsibility of come with being a trustee as well. And another thing is the tax implication that comes with an irrevocable trust, because when you transfer your house into an irrevocable trust, you lose the step-up basis. Now, a couple years ago, you could still keep the step-up basis, but the law has changed since then. And so let's say you bought this home back in the time when it was 2007, when there was a crash. You got it for like maybe $100,000. Well, now it's worth $600,000-$700,000. If you pass it through the revocable trust or just through a will, then your children gets to take up the step-up basis. So when they go and sell the home, they don't have to pay any capital gain. But if you transfer into irrevocable trust because you're trying to protect your asset, well, that capital gain follows the trust. And so when the beneficiary or the trustee sell the house, they still have to pay that capital gain. So that's the consideration I always tell the client. You know, do you want this versus this? It's not like a perfect vehicle or a tool to protect your asset. Mm-hmm.
Is that state specific?
Right now, it's more federal. Yeah. Mm-hmm. I believe you had your hands up earlier.
I was wondering, how does get around? How does the property manager have any bearing on the LLC?
The property management company, from what I know, is their contract push all the liability on you.
Yeah.
But what I know about reading majority of those contracts is they put the liability on you as the owner of the house. So even though they manage it, they say they bring in people for repair, but they cover themselves pretty good. Like they would bring in licensed contractors to do any repair so that they wouldn't have any liability. But usually for the homeowner, sometimes you want to save money, and instead of bringing a licensed contractor, you might go and get a stove yourself and put it in. And that's where the problem comes in. But if you have a contract with a management company, make sure the rental contract's in the name of the LLC so that the checks get paid out to the LLC. Yes.
What is the tax amount mentioned on here? Is that only in the US? How about like other countries?
Oh yeah. So I know that there are certain countries that also gets a pretty high exemption level, but for majority of countries out there, there isn't one. So the moment the beneficiary from another country gets it, I heard that the tax is pretty high.
Let's say if somebody have 4 million here, and then they have assets in other country like 10 million equals to the US dollar amount, like would that be considered they have to pay federal plus state here because they only have 4 million in the US? You know what I'm saying?
I believe that the estate tax only count the asset that is here in the US.
Different laws for different.
Yeah. Because the US really doesn't care about the money coming into the United States. They care about the money coming out of the United States.
Oh, they care about it coming in if it's coming in a 1-year account.
For a legal purpose, and yes.
I mean, they have red flags at these banks that show if you get a deposit of $10,000, you're flagged.
Oh yeah. Oh, talk about that. If you guys own any LLC, make sure you do your FinCEN report, because that's one of the ways that the federal government is cracking down on anti-money laundering. They may actually make you do a report of your company to make sure it's a valid company actually doing business. It's just not a shell company. Mm-hmm.
Yeah, that's why they wanted you to report all your offshore accounts. Obama was in office.
Yep.
I have a question for in case about the conservatorship in case the both parents pass away and the kids still young and need a guardianship. Is that possible to be like the one that non-citizen?
Yes, it is possible, because the court always wants to pick like a close family member to watch over the child. However, if this person doesn't reside here in the United States, then usually the minor will have to go to the other country to live with that person. So preferably, if you're gonna have a guardianship, you want someone here in the United States. And as far as conservatorship, it doesn't matter where, because the court actually restrict all the accounts here in the United States. So you really can't do as you wish. It's very difficult to ask the court to release any money without giving them proper explanation as to why you need that money.
Plus, if that happens, you have to see what the immigration laws are for the country where the child is going, because in most cases, it'll be a U.S. citizen, The person taking it is going to be only a citizen.
Mm-hmm.
So there's different aspects of the laws there.
Yeah. So that's where international laws come in and it makes it even more tricky at that point. Well, thank you, everybody. If you want to talk to me personally after this, feel free to, okay?
Thank you.
Thank you.
Officially say thank you to you. Thanks so much
thank
for
you.
helping me hosting this wonderful seminar, and I'm sure everybody here learned a lot, especially myself today. On behalf of Thai Association of Arizona, we would like to thank you and welcome you to be part of us at our association as well. So any client in the future or anyone, I would like to have you become one of our consultants.
Thank you.
ขอบคุณทุกคนที่มางานในวันนี้นะคะ Thank you everybody so much. If you have any question or any concern or anything in the future, feel free to contact us directly or him directly or I forgot your assistant name.
Oh, Monica.
Yeah.
Our consultations are free of charge. We can do them over the phone.
Mm-hmm.
Yeah, he's wonderful. I've been sending a couple clients to him. So he's very passionate and not the type of attorney that just look at you as a money maker. So, and that was the reason why I really liked him.
I do. I see dollar sign everywhere.
No, he doesn't. He's always wanting to get a discount. I'm like, no.
Yeah, and thank you for the food today too. So he paid me. His firm actually paid for it, and so thank you again.
Of course.
You are the best.
Always glad to be given information. So I speak Vietnamese as my second language. Mm-hmm. Oh yes, of course. Yes.
And you have the business card to give away. So, in case of, we need to contact you
Yes.
for the consultation.
And I believe our phone number is also on the pamphlet too.
Right.
And on a pen too. I like the pen.
The pen, yes.
Green.
Yeah.
You match the theme today. All right. Well, if anybody else have
We have a soft copy to be shared on our.
Like a PDF file. Yeah.
Would you be able to email?
Monica can email you a copy.
We need the PDF on that?
Yeah.
I'll just get your information.